subject to discipline if this happens.
Not without also providing, Your Honor, the opportunity to rebut any finding that the person is, in fact, a danger to the community. And that's where we actually come all the way back to the legislative
Well, the danger to the
purpose.
community, can't the legislature make that determination up front?
Well, in fact, Your Honor, the legislature in this case, in stating the legislative purpose of all of Chapter 456, stated that the purpose of the legislation was to say that the practice of medicine actually is a matter of right unless the person is not qualified. The term qualified is the language used there in 456.003, parens 1.
Okay, let's say there's somebody, I'm sorry for interrupting again, but let's say there's a permit for, or somebody has a business that demolishes buildings, and it's inherently a dangerous activity. And the state says, if you're going to demolish buildings, you are going to be responsible for anyone or anything that is injured. Even if you took the highest level of care, you are going to be responsible for damage done to other buildings in the area, people in the area. We want to put you to such a high level of care. You're going to be responsible. Could the state do that?
Yes, Your Honor, and that's a whole line of cases that actually usually involves blasting cases where it's an inherently dangerous activity, cannot be done in a completely safe manner. And the court, that is not violative of due process concerns to impose liability because it's essentially an inevitable result of conducting that kind of activity is to ultimately result in some danger, physical or injury to persons or property as a result of conducting an ultra-hazardous activity.
I remember about 3 or 4 years ago, maybe it's even longer now, getting old, I can't remember time as well. There were a number of cases out of Tampa where wrong legs were being amputated, wrong patients being operated on, appendix taken out of the wrong person. Can't the state, based on that, have said, look, doctors, we don't want you to delegate this responsibility. You can't delegate it. You are the person responsible.
I would say no, Your Honor, because notions of due process would require that there may be able to create a presumption, but it would have to be a rebuttable presumption, one that could be rebutted by showing that the surgeon did exercise all due care.
How about those cases involving horse racing, where the case law and the statute specifically talk about, and it's been upheld, that the trainer, if there is drugs in that horse's system, the trainer is responsible.
Yes, Your Honor.
How do you distinguish those cases?
That actually goes back to the Supreme Court's Capel case, and in there it wasn't even drugs in the horse's system. It was merely syringes somewhere within the facility, and the court held that was sufficient. But what the court found in that case was essentially the third prong of the Markham versus Fogg analysis, that it is impossible to do a case-by-case individualized determination of guilt in those cases. And the court spoke about the unusual nature of the horse racing business, especially horse racing for the purpose of wagering, and how in that industry it is impossible to make the kind of individualized determinations that are necessary in order to...
Well, there's some uniqueness to horse racing, but isn't there some uniqueness to going to a doctor? You're putting yourself in the care of that doctor. You're under sedation, it's very unique. So shouldn't the state have the same kind of interest in regulating doctors as they do in regulating horses?
Well, the difference there, Your Honor, is that it's not impossible or even difficult in the medical context to make the individualized determination of guilt, which is, as I say, the third prong of the Markham versus Fogg analysis. And it happens every day in courtrooms all around the state when we try medical malpractice cases where the individualized determination of the doctor's culpability is made by a jury. And in this case, it could easily have been made in this informal hearing.
But in those cases, the statute or the common law requires some level of guilt, negligence.
Yes, Your Honor, but the reason for bringing that up is to show that in the medical context like this, it is not possible to meet that third prong of the Markham versus Fogg analysis because it is possible indeed very, very common, to make that individualized determination of guilt. So the irrebuttable presumption that arises from the fact that a wrong site procedure was attempted or even committed is not within the category of items like, say, the Capel case or anything else that might fall within the Markham versus Fogg analysis, because it is possible the board had the ability, and any lay jury even has the ability, to make the determination of whether the doctor was indeed at fault under the unique facts and circumstances presented in this case, rather than simply taking the line out of the statute, holding it up to the light and seeing if facts in the case fall into the blanks. That is a mechanistic process which denies, and in fact in this case did deny, Dr. Sanchez due process, because he was denied that opportunity to rebut the presumption that merely because the facts fit into the blanks in the statute, now he is guilty of this violation.
Well, wouldn't you have had that opportunity to present the facts to show that under this factual scenario he exercised all due care, but you waived your opportunity for a formal hearing and went to informal hearing?
No, Your Honor. In fact, this Court's decision in the Ayala case is exactly on all fours with this. If you look at the statute that was being applied in the Ayala case at the time it was applied, the precatory language of 458.3311 is exactly the same as the precatory language in 456.072 in this case. And in that case, the doctor requested an informal hearing, and just as happened in this case, the doctor was afforded no opportunity to rebut the presumptions that arose from the technical violation of the laundry list that follows in the statute.
Okay, did you request a formal hearing?
We requested an informal hearing, Your Honor, just as the doctor did in the Ayala case.
The statement of facts in the administrative complaint by requesting an informal hearing, right?
Yes. We did not contest the facts in the charging document to the extent they went, because those facts happened. The question is, were there other facts? Was there other evidence? And in an informal hearing, the respondent is entitled to come forward with evidence for the board to consider.
Counsel, is it your position, though, that you can't have a strict liability statute without a rebuttable presumption, even if an individual is involved in an activity that involves great risk of danger to a member of the public?
And in the Fogg analysis, the answer to that question is yes, it is my position, and unless you can meet that third prong of the Fogg analysis, which is that under the circumstances of the particular industry or the whatever is being regulated, it is impossible, impracticable to make individualized determinations of guilt. And in the absence of being able to meet that prong, and we know that you can't meet that prong, because, as I say, juries do it every day in our court system. If you can't meet that prong, then you cannot have an irrebuttable presumption. Due process requires that the physician be given an opportunity to rebut that presumption, and not on the question of mitigation of the discipline, but actually on the question of whether there's guilt, whether there's been a finding that would satisfy the legislature's stated intent that the practice of medicine be deemed a matter of right unless the person is deemed not qualified or unless there's a showing that the person creates an actual danger to the health, safety, and welfare. I see I've gone into my rebuttal time. If there are no other questions, I would ask simply that this Court reverse and remand for a fair hearing.
Oh, and I'm sorry. I apologize. I got busy. I'll give you a little bit extra time if you need it.
May it please the Court, my name is Wings Benton. I'm Assistant General Counsel with the Department of Health, and I'm here today representing the Appalachia Department of Health Board of Medicine. The final order of the Board of Medicine should be affirmed. The legislature has made it very clear in the statute under which Dr. Sanchez was found to be in violation that a wrong site procedure is essentially per se a violation. Dr. Sanchez has attempted here this morning and in his brief to argue that this prong in Fogg cannot be met. I think the legislature, by virtue of making this statute, is is exclaiming that it feels otherwise. In other words, that there was such a problem that it needed to be addressed through a statute as direct and clear as this particular statute.
What about the third prong of Markham versus Fogg?
Pardon me?
The third prong of Markham versus Fogg
Yes.
that the council relied on.
Yes, the council.
Do you agree that that's the law and that in order to impose discipline without giving somebody an opportunity, strict liability for discipline, that you have to meet the third prong of the Markham versus Fogg test? And is it applicable to this case?
I think you can get there without an analysis of that, but I'm trying to rebut his application, his argument that the third prong cannot be met. I think the legislature has seen that there is such a problem with wrong site procedures in the state of Florida that it needed to protect people through a statute of this type. And I would prefer to rely on the cases of Capel and U.S. versus Dotterwike, in which the court said, it is now well established that in areas of activity requiring strong police regulation to protect public interests, strict liability may be imposed upon persons otherwise innocent but standing in responsible relation to a public danger. But I would submit to this court also that this court does not even need to go there. Dr. Sanchez is asking this court to hold a statute unconstitutional, to rewrite a statute for him when the facts simply don't bear out his argument. He was allowed to put on at the board hearing, the informal hearing before the board, a lot of evidence and a lot of argument through his counsel and through his own testimony, about 7 pages of his own testimony. He argues in his brief that this occurred after they had already found a violation. However, before they found a violation, the department prosecutor said, at this point, this is after the board had adopted the findings of fact in the administrative complaint as the findings, had adopted the allegations in the administrative complaint as their findings of fact, because he had requested an informal hearing. This is the type of hearing he requested. This is the type of hearing he wanted. He admitted all the facts in the administrative complaint. So the department prosecutor said, at this point, the department believes that it is appropriate to entertain a motion finding the respondent in violation of Florida statutes as charged. And then later, the department prosecutor says, after they vote to find him, to find the facts as alleged in the administrative complaint, the department prosecutor says, at this time, it is appropriate for the respondent and the respondent's counsel to address the board concerning legal argument and or mitigating evidence.
Okay,
So,
I hate to go back to something, but it's slipping my mind. What was this in Markham versus Fogg? Are you familiar with the facts in that case?
I'm not familiar with the facts in Markham.
Because I was going to ask, and I think in my mind that there was an irrebuttable presumption involved there. We're not talking about a presumption here, are we?
There is no presumption in this statute, Your Honor, and that is the position of the agency. The legislature put no presumption in this statute. Dr. Sanchez is arguing that this case is on all fours with Ayala. Ayala did involve a statute with a presumption. The statutory presumption in Ayala was that a nolo contendere plea shall be considered a conviction. We have nothing like that in this statute. What we have in this statute is a very clear statement of what shall be a violation in order to protect the public from a very grave danger. He argues that it's not possible in the horse racing cases to determine who's at fault and so forth. And I think that the same sort of thing has occurred with these wrong site cases, the shifting of blame and people, particularly doctors, trying to shift blame to the nurses. And the legislature has made it very clear through this statute that you cannot do that. A board member, an anesthesiologist, said to Dr. Sanchez after he had spoken for 7 pages of transcript here, I am a little bit concerned that I'm hearing a little bit of attempt to shift blame. And yes, indeed, the nurse has responsibility for making sure the appropriate procedures are done, but I'm the anesthesiologist on the board. and I work at the University of Florida, and we do timeouts. Now, Dr. Sanchez had already admitted that he did somewhat of a timeout procedure before he stepped out of the room and allowed the nurse to prep the patient. When he stepped out of the room and allowed the nurse to prep the patient, and he came back in to begin the procedure, all he did was say, and this is through his own words, his testimony before the board. In fact, what I did ask her was, is this area prepped and correct? She said, go ahead, doctor, it's already been prepped. That's not what I want my doctor to do. I want my doctor to look at me. I want my doctor to know my record. I want my doctor to know that if my left thumb is to be operated on, then he should not be doing an interscaling block on my right side. He should at least know me, know the record. Dr. Sanchez is asking this court to hold a statute unconstitutional wholly unnecessarily based on the facts of this case. He got what he asked for. He admitted the facts. He gave facts in his testimony to the board. The board listened. The board listened to his counsel, Mr. Bruce Lamb, for pages and pages, until Bruce Lamb said thank you and stopped, never offered to put on Dr. Sanchez at that point. And only at that point did the board decide that it would go on and entertain a motion on whether there was a violation of law. So no one on the board failed to provide him a meaningful opportunity. They listened to all of his arguments about the factual scenario of what happened with this particular patient. The board saw no reason to deviate what it has done in a myriad of cases, which Mr. Lamb had spelled out in written documentation to the board. He had 13 cases, and this is just a smattering of ones that he had selected that to show what types of penalties the board has meted out in these cases. Cases involving prepping the wrong eyelid, places involving an incision on the wrong finger, situations where the incision is on the wrong knee, where there's anesthesia to the wrong eye, where there's a retrobulbar block on the wrong eye, 2 cases like that. Those cases are very similar to Dr. Sanchez's. And why should this board change its interpretation of the statute for Dr. Sanchez? The board is entitled to make this interpretation of its statute. The board has an anesthesiologist on it. The board knows what kind of care the doctors should be held to, and the legislature has done nothing improper by declaring in this statute that a doctor is responsible for getting the right side when operating on a patient.
Let me take it to the point of absurdity. Doctor comes in, and the nurse says, doctor, I checked the record. I prepped the appropriate side. She's lying to him for whatever reason. Would the doctor still be liable in those circumstances? Is that a problem?
The doctor has a duty to check the patient, to know the patient, to know where he's operating and so forth. We had a case in the 3rd District Court of Appeal where an attending physician was in the room with a resident performing surgery. A resident has a license and was actually doing the surgery, got the wrong site. And the doctor tries to defend that I wasn't doing the surgery. The resident was doing the surgery. I wasn't looking over the patient. I wasn't standing right there. It was affirmed that the attending physician was responsible for that patient and for the oversight of that resident. The doctor cannot delegate to the nurse, and that is why it's necessary to have a statute like this, because of shifting the blame, which the board member at the board meeting noticed was going on and kind of caught Dr. Sanchez on that, attempting to shift blame and yet saying there's something wrong with the statute. Dr. Sanchez received due process. He asked for an informal hearing, and he was given an informal hearing. And at that informal hearing, he was treated with courtesy and with great deference. The board members were polite. They were listening to him, to everything he had to say. And this is not a case, at least on these facts, that rises to the level of rewriting a statute for Dr. Sanchez's benefit. Thank you.
Thank you. Help me in my old age here. I read Markham yesterday, and I remember saying to myself that this is distinguishable. Can you give me the facts again? I can't remember what the facts are.
Markham versus Fogg involved agricultural classifications of land for ad valorem tax purposes, and the presumption arose, if I'm not mistaken, this was the 3 times rule, sale for more than 3 times the agricultural value.
Okay, so they were dealing with a presumption there.
In that instance, Your Honor, the presumption was expressly laid out on the statute. Here, the presumption is concealed by the way the language is drafted. But what Ayala tells us, what Surf Properties tells us, is that due process requires that there be an element of guilt before this kind of a violation can be found. So what we essentially have is a sub silentio presumption that if you perform a wrong site procedure, it is presumed that you had guilt or that you had
What if the
culpability.
statute said you cannot delegate the responsibility to determine where to operate to a nurse? Would that be a problem?
I'm not sure that it would involve the same kind of issue, Your Honor. I don't think it would be a problem from a due process standpoint, because then that would be essentially mandating that the doctor not just rely on the timeout procedure, which, by the way, is a good procedure, and I'll get back to that in a minute, but not just rely on the nurse saying, this is the right side, I prepped the right side, that side is prepped, the IV's on the right side, all the other indicators that a doctor would look at. Instead would say, instead of relying on those, a doctor would then have to go back and redo those steps.
Why isn't that basically, though, what the statute says here? We are not letting you delegate the responsibility to anyone else to make a determination of where to perform the medical procedure.
Well, actually, Your Honor, the legislation
I'm not
doesn't
saying
say that. Yeah, the legislation doesn't say that, but it almost does put the onus on the doctor to be a lone wolf in the room, and essentially deprives the patient of the benefit of an entire team of medical professionals working for them. Now, obviously, that has some risk, because some people do make mistakes. That happens. But you would essentially have the doctor being the person going in and prepping the area, the doctor being the one going in and putting in the IV. And those are not things that in normal practice people do, nor is it good medicine. Good medicine is to have a team of professionals that each perform their own job. If somebody lets down on that job, then that person's responsible. It doesn't mean that everybody else on the team is responsible in the due process context. The other point I wanted to make, and this goes back to the use of the informal hearing process. The informal hearing process does not cut off the respondent from the ability to put in evidence in addition to other undisputed evidence, in addition to what's in the charge, in order to show a lack of guilt or a lack of culpability. That is what Dr. Sanchez was deprived of in this case. The board's interpretation of the statute on appeal is consistent with what the board's interpretation of the statute was below, and that is, if there's a wrong site procedure, end of story, end of case, we move on to the level of discipline. And due process requires that Dr. Sanchez, and any other doctor for that matter, be given the opportunity to come in and show.
Why isn't this just like a motion for summary judgment? There's no dispute on the facts. We're only going to interpret how those facts apply to the law.
In essence, Your Honor, that is correct. That's what it would be like. But there would have to be the additional evidence, the opportunity for Dr. Sanchez to bring in the additional evidence. So, in other words, the non-movement in a summary judgment context is not limited by the movant's affidavits. Rather, they're allowed to bring in their own discovery items, depositions, et cetera, to show that there is a disputed issue of fact, or in this case, a lack of culpability or guilt. And that is what Dr. Sanchez was deprived of in this case. Seeing over my time, again, I would ask that you reverse and remand for a fair hearing. Thank you.
Thank counsel for the excellent arguments. There will be no further cases before the court. The court will stand in recess.